So my name is Giulia Sajeva, and I'm a Marie Curie Fellow at the Strathclyde Centre for Environmental Law and Governance at the University of Strathclyde, and I am going to talk about rights for ecosystem services rights. As I'm sure you all know, the connection between human rights and the conservation of the environment is really strong. It's easy to imagine how human rights need a well-protected environment to be fulfilled. So the right to food, the right to water, the right to healthy environment itself. But also the environment and the protection of the environment can benefit and needs to benefit from well-protected human rights. That can be rights to participation, so to information, for example, to know whether a certain project has some negative effects on the local environment, but also to protest, to say that I don't agree. So that also concerns the prior informed consent of indigenous peoples and the right to self-determination. However, human rights, because of their history, they are an anthropocentric instrument. They were born to protect especially and fundamental interest of human beings, and that's what they are meant to do. So the human beings are their beginning and their end also, which means that there can be contrast with the protection of the environment at times, as well as on the other side, as we have seen in many cases, the protection of the environment can hinder the protection of human rights, for example, in the case of indigenous peoples being evicted from their lands. Now, the question that is really behind the framework that I am trying to develop, and it is still work in progress, is whether human rights can be framed in a different way that can truly incorporate the vulnerability of the earth and the limits of natural resources. In order to try to move in this direction, in about 2010, there was a big proposal by Kabir Sanjay Bhavikatte, who is an Indian scholar and activist, that proposed the idea of bicultural rights, which was really truly presented as a win-win solution. The idea behind bicultural rights is a basket, actually the basket of rights of indigenous peoples and local communities, which needs to be recognized in order to maintain their role of stewards towards the environment. So they build on the recognition of the contribution that indigenous peoples and local communities, that many indigenous peoples and local communities have for the conservation of the environment, but also on the recognition of the fact that if their rights, the human rights, the rights are not fulfilled, well, they cannot maintain and thrive their stewardship role. So the bicultural rights, would be like a basket of rights to land, the rights to self-government, the rights to institutions, rights to conserve different cultural identities, and so on. Bicultural rights cannot be said to be recognized in international law at the moment. They can be said to be de jure condendo, which means that they are possibly developing in international law. It can be interpreted from the looking at many declarations and conventions, starting from the Convention on Biological Diversity and the Nagoya Protocol, but also looking at court cases, such as the Wanganui River case in New Zealand or the Atrato River case in Colombia, which actually is the first to explicitly mention bicultural rights. The idea is that bicultural rights present themselves as win-win solutions, able to at once fulfill the interest of indigenous peoples and local communities and the environment. So they can be called environmentally conditioned human rights. Why? Well, because they can be granted only to those communities that actually are sustainable by definition, and they require those communities to remain sustainable in order to maintain their to remain holders of bicultural rights. And these actually, after being accepted with very great enthusiasm, then there was a moment of like, okay, well, let's be careful though, because when we're dealing with indigenous peoples, we have to remember that they are already holders of indigenous peoples' rights that are quite well recognized in international law and in national law, even though very often they are not respected. They are, at least in theory, recognized, starting from, for example, the UN Declaration on the Rights of Indigenous Peoples. So that what was said is, let's be careful because we cannot, because bicultural rights are the requirement to indigenous peoples. They have to be sustainable in order to obtain these bicultural rights. Then why should they be asking for bicultural rights? They already have indigenous peoples' rights. So there have been a lot of critiques on this and a lot of discussion. And well, in my previous works, I've elaborated on the fact that bicultural rights can still be useful for indigenous peoples, especially in those moments in which, for some reason or another, they don't see their indigenous people's rights recognized. But that has to be a choice that they have to make, and they need to know what the price is. But I think that bicultural rights give us an idea of how to try to combine at once in human interest and environmental interest. So we should not throw out the baby with the bathwater. So let's try to move beyond bicultural rights, and let's try to focus, which is really the concrete aim of my project, our attention towards what is local communities. Of course, the definition of local communities is very complex, it's not very defined, it's not very simple, but we can look at local communities, as those groups that act collectively in ways that contribute to defining a territory, a culture, an identity, and that aim at promoting and moving it to future generations. But that are not local communities, that do not fit that strict test of indigeneity for one reason or another. So, for example, there could be local communities of descendants of former slaves brought to South America from Africa that have moved to live in ways now that they freed themselves, in ways that are very similar to local indigenous peoples, but they cannot access to indigenous peoples' rights because they are not indigenous. So the idea with bicultural rights is to try to shift the focus towards local communities, including also non-traditional local communities. So they can be more or less traditional farmers, but also eco-villages, engaged citizens. So also to concentrate not just on developing countries, where we always go and with the idea of trying to tell them, well, you have to protect your environment, but actually looking also at the Western part of the world that also can and has to act towards protecting what is left of the local environment, also through the support of local communities. Where to start from, trying to put this together. An idea was to try to look at putting bicultural rights together with another instrument that was proposed as a win-win solution, which are payments for ecosystem services. They were presented as a great way to talk to politicians and the private investment world, because they provide a very simplified language. You pay for a service that a community is providing to you by maintaining its traditional ways of life, for example. And you pay back for it. You being a city, the state, an international investor. If you think of RED+, for example, it's a payment for ecosystem services framework. And it was represented as a win-win solution. You contribute to protect the environment, but also to alleviate poverty. However, the critiques that have been raised against payments for ecosystem services, especially against certain ways of implementing them, are many. And I'm just gonna go through very few of them. First of all, being the fact that the interactions between humans and nature and between providers and conservers of the environment are downgraded basically to simple economic interactions. They also assume that a monetary incentive is useful for a community, or is desired, or even more brutally, is effective. When a thing that has to be considered is the fact that when you substitute a social, a cultural incentive towards making something that is environmentally beneficial with an economic benefit, well, then if the payment goes away because the donors goes away or for whatever other reason, you are at least losing also the social and cultural reasons for doing that activity. Also, payments for ecosystem services are very often unable to factor in other knowledge systems, such as traditional knowledge systems, and they may also exacerbate local inequalities issues, such as income issues, gender issues, or lack of access to resources and decision makings, but also shade other important factors, such as vulnerabilities, the importance to ask for free prior informed consent, identities factors, the fact that many communities lack land titles, like legal land titles, and so on. Now, trying to respond to the IPBES, which is the Intergovernmental Science Policy Platform on Biodiversity and Ecosystem Services. They called for a turn towards a more rights-based approach for ecosystem services, capable of truly incorporating cultural pluralism of local communities. We can try to learn from both payments for ecosystem services and bicultural rights, and basically adding the rights ingredient to payments for ecosystem services, accepting the need to increase our understanding and understanding of policy instruments of cultural and social interaction, and adding more and more participatory approaches. So the idea that would come out are rights for ecosystem services. So rather than payments for ecosystem services, rights. They would, of course, require no payments in returns, but actually rights. So just as bicultural rights were saying, we have communities that are protecting the environment, let's recognize their rights to lands, natural resources, whether they are indigenous or not, whether they are local communities, whether they are traditional or non-traditional communities. Let's try to give them the rights that they need to protect this local environment, to remain or to become, in certain cases, stewards of that environment. So that would be like rights to property, including common structures of properties, or to extra quotas in the use of natural resources, if you think of fishing communities, for example. Special rights to seeds exchanges, which links us to the whole intellectual property issues with genetic resources of seeds and plant materials. Or also special access to sacred natural sites that are protected or that they want to protect, they want to worship, but also protect. Of course, these rights, the rights for ecosystem services, would be rights coming with obligations, which means you obtain these rights that other people do not have because you have an environmental stewardship role, but therefore you have to maintain this stewardship role. So they would be special rights. They would not be human rights meant as fundamental rights, entrenched in constitutions or the Declaration or the Universal Declaration on the Rights of People. So that would be rights granted only under these conditions. Of course, that would take us away from some of the issues of payments for ecosystem services. For example, first of all, we would not need to determine their monetary value of a certain ecosystem service. There would be less reliance on external funding, and we would not need to focus solely on indigenous peoples. Indigenous peoples could also, of course, always enter a rights for ecosystem services policy frameworks. But of course, that would be only in the case in which their indigenous peoples' rights, they're already given them rights to land and natural resources, are not fulfilled for some reason. For example, because they are denied, as I was saying before, their indigenous status, or because there's a state that is just going against them or their recognition. So what RES, so Rights for Ecosystem Services, could try to do is to help reconceptualize rights as embracing both human interest and environmental protection interest, thereby trying to overcome the classic anthropocentric and ecocentric dichotomy, which still characterizes literature on one side on conservation science and on the other side on human rights theory. Of course, there are many issues that still remain, such as, for example, is it just a cosmetic action? Because we're still talking about ecosystem services, and we keep a very anthropocentric approach, maybe. Or also, what do local communities think about it? And this would be the second part of my project, which due to COVID reasons has not been taken forward, which should lead me to do some field work in European local communities. But also questions related to, for example, what it means to be sustainable, what it means to conserve the environment. Local communities and a state could have very different opinions of that. What level of protection would be fair to be asked to a community if we don't want to shift the burden of conservation to communities once again? So overall, I think further steps are needed to understand better rights for ecosystem services, but more in general, to understand whether the environmental limits can be incorporated into human rights as fundamental rights, not just human rights as not just special rights, as is the case for rights for ecosystem services. Okay, well, thank you very much. I'm going to exit